The constitutionality of the Electoral Act was put under scrutiny in June 2020.
It is declared that the Electoral Act 73 of 1998 is unconstitutional to the extent that it requires that adult citizens may be elected to the National Assembly and provincial legislatures only through their membership of political parties. 5. The declaration of unconstitutionality is prospective with effect from the date of this order, but its operation is suspended for 24 months to afford Parliament an opportunity to remedy the defect giving rise to the unconstitutionality.
The deadline for Parliament to rectify the defect in the law is more than a month away, but the National Legislature says it won't be able to honor the Concord Directive on time. It wants the Constitutional Court to grant it an extension.
Given the significance of the bill and the required public participation process, it has since become apparent that Parliament will not be in a position to pass an amendment to the Electoral Act before the June deadline. The bill was only introduced to the National Assembly on the 10th of January this year, leaving Parliament with only 5 months to process a bill of such public significance and interest. Accordingly, the presiding officers of Parliament have approached the Apex Court to seek an extension in order to enable Parliament to properly deliberate on the bill before it and to ensure that citizens across the country are afforded an opportunity to meaningfully participate and share their views on the Electoral Amendment Bill.
However, one South Africa movement is not impressed with the delay by Parliament.
This delay is most unfortunate because it symbolizes a Parliament that has taken its time in being able to process this. We will be considering all options as to whether to challenge it in court, because ultimately what you want to do is to make sure that the day comes we can hold the state accountable, elect the best people, and I'd rather have a perfect bill that ensures that we're in a constituency-based system rather than have the one that they've proposed being rushed through.
Nationwide public hearings were held in various parts of the country in March. Those who participated and made their voices heard expressed their different views on the bill.
If that independent candidate becomes a public representative and he passes away, who replaces him? Now, I believe that the idea of the list of beneficiaries for independence that was proposed in the private members' bill of the quota.
Independent candidates are limited to only 200 seats in Parliament. Independent candidates are not allowed to contest for the 200 national seats. This is purely unfair. We cannot have a democratic country and we treat independent candidates as if they are not from this country. No. They are also citizens of this country, just like me and you. We are creating a system now where we are saying, okay, you can come in, the politicians come in, but independent candidates remain outside. Are we calling that democracy? No.
The independent, local independent candidate, I didn't see any fruit from that person locally. How much more provincially and in Parliament? It's going to be chaotic because in this country we're having a problem of identity. Even a person can commit a crime, it's very hard to get that person. Therefore, I don't support the motion.
We're at a crucial time in the history of the South African nation when the citizenry are questioning the accountability of the state. The key to this concern, in my opinion, rests in the whole matter of electoral reform, and we have to have a quick look at the history. In 1994, at the dawn of democracy, the original simple system put in place was straightforward proportional representation, designed to give stability to a new democratic state and reflected in the Constitution. But it was not, definitely not intended as a permanent electoral system.
After 18 months, the electoral amended bill was gazetted on the 21st of December 2021 and introduced on the 10th of January 2022 for comment by 21st February 2022. We hold that Parliament has failed to fulfill the mandate to ensure transparency or to secure participatory democracy by failing to introduce the bill timelessly, thus limiting the public's opportunity for meaningful responses.
We are saying that there has to be an accountability in terms of, let's say that people at least must have associations as independent candidates that they are affiliating from, so that whatever that is happening, those associations will be accountable for the independent candidate for the conduct that they are having in the parliament.
Days after Parliament asked for an extension, the Home Affairs Department appeared before the Parliamentary Committee to brief it about the outcome of the public hearings. The department has also defended itself on why it delayed to make electoral amendments on time.
We took a long time before we came with a policy after the Constitutional Court judgment. We were criticized for that. There was a belief that we were scared to make any changes. But we took a long time because we were studying electoral systems around the whole world. We tried everything in our power, and we gave you an example of a few during my first presentation in Parliament. There is no electoral system anywhere in the world that is so perfect as to meet all the concerns and the desires of people in that particular country.
Concerns were raised in the National Assembly Program Committee about the implications if the Constitutional Court does not grant Parliament an extension.
The fact that an application for an extension has been filed doesn't necessarily mean that it will be granted, and there has been previous Constitutional Court judgments where extension requests have not been granted. What would be the implications if an extension is not granted, or because there's a strong possibility that the litigants involved in the New Nation movement might oppose an application for an extension?
So if the court does not grant the extension, all that we can do is to simply proceed with the bill as soon as possible. It is not, there was no invalidity. It's not that type of judgment. It's not something where something was in action at the moment and it was declared invalid and we had a certain time, and if you reach that time, that invalidity has serious immediate consequences. In this instance, there's an order to do it at a certain time. If we don't do it, by the time we have the next elections, it will have to be in place, or our elections will not be constitutional. So that is more where this is lying. It is, of course, better if we can get the extension.
If the Electoral Act is amended on time within 6 months as requested by Parliament, it could pave way for independent candidates to participate for the first time in the national and provincial elections in 2024, once the bill is signed into law. Mercedes Besant, SABC News, Parliament.